welcome back, Faithful Politics listeners and viewers. If you're watching on our YouTube channel, I'm your political host, Will Wright, and your faithful host, Pastor Josh Burtram, is too scared to be here today. So you've got me all by yourself, but not necessarily, because I have with us Caroline Mala Corbin. She is a professor of law at the University of Miami School of Law. She teaches U.S. constitutional law, First Amendment, the Religious Clause, Free Speech Clause, feminism, and the First Amendment, and advanced topics of reproductive rights. Her scholarship focuses on the First Amendment speech and religious clauses, and we are so excited to have her here today. So welcome to the show, Caroline.
Thank you for having me.
Yeah, so you're calling us from Florida, right?
I am in Miami right now.
Nice. So how does it feel to be in the liberal stronghold in a conservative state?
Not so liberal.
Didn't the mayor or something like just win kind of like a freak election or something?
I must confess I'm not sure, but I'm originally from New York City, so this is still less liberal than I grew up with.
I hear you. I hear you. Well, I'm not necessarily trying to, out your political preferences or anything like that, but but Florida's been high on my mind. By the time people are watching this, there would have already been a debate that had happened. But we're not necessarily here to talk about that. We're here to talk about your expertise. So you have made it your career studying the First Amendment, religion clauses, and equality issues. So can you explain like what happened in your life that made you decide that this is an area of focus for you?
I actually started in reproductive rights. So one of my first jobs was at the ACLU Reproductive Freedom Project. But in this country, you can't do reproductive rights without running into religion. Religion really is the major obstacle. And so that's how I started shifting my focus to religion. And I'm also a member of a minority religion. So I think both of those sort of led me towards the First Amendment. And as you said, my approach is I sort of approach these issues through a equality lens, because what I care about are those with less power and their rights and
Yeah, that's interesting. So you said you can't really approach abortion without talking about religion. I don't think I've ever heard that perspective before. I mean, I've thought of that, and I can do the same thing with LGBT rights and all kinds of other stuff. But I'm interested to hear what's sort of your experience with the nexus between those two.
Well, the major opposition to reproductive rights, or certainly if you're thinking about abortion, opposition to abortion is in this country very much based on certain theological beliefs about when life begins. And so I think much of the opposition to providing this basic health care to women across the country is rooted in religion. And unfortunately, it has now become part of our law. So, and the same thing, unfortunately, it's not just limited to abortion, the same thing with contraception. Very often, like we actually managed to have a federal law that required health insurance companies to include preventive care, which includes contraception. And then you had people religious companies challenge that on religious grounds, and they won. And so now women don't have that access to contraception, that basic health care, again, because of religion. So that's at least one way that religion is really an obstacle to women's full reproductive rights and reproductive justice in the country.
Got it. And it seems like a lot of these conversations about abortion, about LGBTQ, about, I don't know, churches being open during COVID, all kind of revolve around this idea of religious liberty. We've spoken to a lot of professors, a lot of really, really smart people. I don't think I've necessarily spoken to anybody that's focused just on religious liberty. So I'd love for you just to unpack that, because it seems like it's a very loaded term that has a lot of different adjacent themes.
Okay, so um, our Constitution protects religious liberty in the First Amendment, and I would say there are actually two different clauses that protect it in slightly different ways. So we have what's known as the Free Exercise Clause and the Establishment Clause. And the Free Exercise Clause protects your religious liberty by barring the government from targeting religion for disfavor. So the government can't say it's illegal to believe that Saturday is the Sabbath day, or that we are going to, make it illegal to observe the Sabbath on Saturday. So that would violate the Free Exercise Clause. It protects your actual practice of religion. But that's not the only clause that works to protect religious liberty. There's also the Establishment Clause. That's the clause that says the government can't make any law establishing, respecting the establishment of religion. That's basically the one that says there should be some distance between church and state, right? To the extent we have separation of church and state, it's grounded in the Establishment Clause. And the Establishment Clause protects the religious liberty of minority religions by barring the government from favoring one religion over others. Because when the government favors one particular religion, usually the dominant religion, that inevitably is bad news for religious minorities. Right? It's, as Madison noted, it's often the first step to religious persecution. But even if it doesn't end up in persecution, right, at the very least, if the government says this one religion is the preferred religion, you've basically made second-class citizens of everyone who does not belong to that dominant religion. So I think it's really important to understand that there are actually two clauses in the Constitution that promote religious liberty, and they do it in slightly different ways. And the Establishment Clause, that separation of church and state, is as important for the religious liberty of religious minorities as the Free Exercise Clause is. That's my pitch for the Establishment Clause.
I love it. No, I think that's great. And we spoke with a judge who wrote a book. Oh gosh, the name escapes me, but it has something to do with how the founders like thought about a variety of different issues or whatnot. And I asked him this question, the question I'm going to ask you, basically about how, Jefferson wrote the letter, Danbury Baptist, what have you, church state separation. And, I mentioned to him that, okay, so that particular line isn't in, verbatim in the Constitution. So like, how do we go from like, okay, separation church and state is good or bad, but also, take into consideration that, well, look here, I'll back up. I'm going way too fast. So like his view was that the meaning of the church state separation primarily focused on government interfering in church. So state, impeding on church. And he says that line isn't even in the Constitution. So, and I'm paraphrasing here, that we have really gotten that all wrong, and there's nothing wrong with kind of this blending of church with state. It's just we can't have blending of state with church. So I love for you to kind of maybe explain that, unpack that. Like are the two sort of notions, the Danbury Baptist letter and the two clauses that you mentioned, are they like in conflict with one another? Do they kind of work in concert? And what's your response to somebody that says that's not even in the Constitution, so we don't really have to worry about it?
Well, given that the First Amendment given that each of these clauses is only a few words long, right? Most of the doctrine that we live by is not spelled out in the Constitution. It basically says you can't prohibit the free exercise of religion. What does that mean? Who knows, right? The Constitution doesn't say what it does and doesn't encompass. Same with the words respecting an establishment of religion. It provides us not a lot of detail on how we should apply these. But if we understand them as protecting religious liberty, then I think that probably should guide how we interpret them. I think the person you spoke to was an originalist who thought that we should understand the Constitution in exactly the same way as the founders understood it, and not just the basic principles, but actually the applications. That is one theory of constitutional interpretation and not the one that I happen to support. I'm more in favor of saying there should be certain principles that were established at that time, and how we apply those principles have to change as we as a country, as the composition of our country, as the values of our country shift. So should our understanding of these basic guiding principles. So I don't really care exactly what some people thought. And even if you do, I just got to say there's a lot of controversy among scholars about what the original meaning was, right? So if I focus exclusively on Jefferson and Madison, we're going to come up with a very different historical understanding of the Establishment Clause than the professor that you spoke to. But I don't want to engage in that debate because I don't really think that's the best way for us to think about our Constitution. Again, I want to say, I think one of the things they do is work in concert to protect the religious liberty of everyone. And I think it's really important for religious minorities, for their religious liberty to be protected, for them to have space to live out their faith, that the government not favor one religion over others. And so that basic guiding principle, I think, really is core to our understanding of what the Establishment Clause requires. And you can phrase it as separation of church and state, but you don't have to, right? It's enough to say that it means the government can't say this one religion is the primary religion, is our preferred religion, is the religion that we are going to promote and endorse and advocate for. That, I think, is an understanding of the Establishment Clause that does not insist on separation of church and state. And I think you'll have, even if you want historical roots for that approach, you can find them.
That's interesting. So I'm curious, in your field of study, I'm curious if you can tell us what do people kind of get right and what do people kind of get wrong? And I know that that's a very broad question because, like, on one side, depending on maybe where you land politically, like, you can just sort of, recite all the talking points of one side and all the talking points of the other side. But I mean, is there like just a broad consensus of things that people kind of get right about religious liberty, and then that the same for the things that they get wrong?
I don't know if there's a consensus right now. I can tell you what I think the Supreme Court has gotten wrong, at least recently. And I think that the problem is that the two clauses are sort of out of balance. I would say that generally the Supreme Court has eviscerated the Establishment Clause along with its protection for religious minorities. So, for example, it now does not violate the Constitution for a small town's political meetings to start with Christian prayers, like government-sponsored Christian prayers, is A-OK according to the Supreme Court. I think that's really problematic. And that was made possible because of the way they understood the Establishment Clause. At the same time, I think the court has privileged religion and religious exercise over everything, right? Including really compelling interests like public health, like reproductive health, like LGBTQ rights. So, for example, I sort of started mentioning this earlier. There was this Hobby Lobby case where there's a billion-dollar company owned by a small family. They had thousands of employees, and there were certain contraception that they personally opposed. And so they said they had a religious right not to include it in the health care they provided their employees. So it wasn't like they said, well, we think these contraceptions are wrong and we don't want to take them. They said, we think this contraception is sinful and therefore you can't take it, even though there's a law that says you have a legal right to access this. That, I think, is out of whack.
Yeah, you know. Oh, go
No,
ahead.
no,
I
no,
didn't.
I mean,
Um,
that's just one example.
yeah, you know, and you so you wrote about excuse me, the Supreme Court in an article, Supreme Court's facilitation on white Christian nationalism, and I think you bringing up the Supreme Court is probably a good segue because, you know, at least in the time that we've started this podcast back in 2019, I mean, there's just been like a ton of different Supreme Court cases that have been on the books, many of which we've talked about, like Kennedy v. Burtram and all kinds, and a number of the other ones. So I'm curious if you can maybe unpack, you know, what you included in the article, and I'll make sure I'll put a link of it in the show notes, about, you know, how the Supreme Court, you know, has been facilitating white Christian nationalism.
Okay, so that article is a few years old
Mhm.
already, so I don't remember which were the main cases at the time. But let me first start by explaining what Christian nationalism is. It's become a more familiar term in the media,
Mhm.
and it's probably more accurately described as white Christian nationalism because it's more of a identity really than a religious belief. But the basic idea is that United States has always been, is currently, and should always be a Christian nation in terms of its identity, its symbols, and its policies. That is, right, rather than any separation of church and state, Christian nationalism wants to have a union of church and state where that church is the particular collection of conservative Christian beliefs. So again, it's not about religiosity, it's about the marriage of religion and the government. And I hope it would be plain that Christian nationalism's goals for the government to impose sort of conservative Christianity on everybody in the country is really contrary to some of the bedrock principles of the United States, which is supposed to have religious liberty for all. And my paper, as I mentioned, was written several years ago, basically argues that the Supreme Court has facilitated Christian nationalism. It has made possible the adoption of Christian policies and the imposition of Christian theology, and generally the favoring of Christianity over other religions in its decisions. So it's partly done this by basically taking a wrecking ball to any separation of church and state. Um, so, in addition to that case where they allowed a government to start its legislative sessions with Christian prayers, it's also said it was just a-okay for a government to erect a giant Latin cross in the middle of a highway, on the grounds that it wasn't really that Christian. It was about honoring World War I veterans. They've kind of eliminated any restrictions on funding private religious schools, which are all really basically Christian schools, which is a complete turnaround because once upon a time it violated the establishment
Mhm.
clause for taxpayer money to go to religious schools. And now it violates the free exercise clause if the government doesn't give money to religious schools, if it makes money available to private schools. And I mean, certainly the recent Dobbs decision, which makes it possible for states to ban abortion entirely, as we've discussed, like that's really a religious belief. And that enables states to impose a conservative Christian view onto women across the country who may not share that religious view, right? The prior regime allowed everyone to live their life according to their own views. So if you opposed abortion, you didn't have to have one, right? But if that's not your belief, and actually some religions require abortion in certain circumstances, the law no longer allows that.
Mhm. So, which religions are those?
So, for example, in the Jewish faith, right? Life does not begin at conception. Life begins much later. I mean, they're understand. So Jewish law also believes that life is precious, but it does not begin at conception. It begins, I think it's at birth. Now, I wrote an article about this. I should know this well, apart from being Jewish as well. But it's like it starts at birth.
Sure.
And but because life is sacred, if there is something that is threatening a woman's life, it should be eliminated. And that's true for her life or her well-being. So if there's anything that's threatening that, it can be sort of required to bring it to an end. And that can mean a pregnancy, which threatens a woman's well-being. There are ways to interpret Jewish law such that it should be terminated. But the laws that ban abortion at 6 weeks or immediately don't allow Jewish women to live their to honor their own values with regard to pregnancy. So, and I'm only using Jew, that's just one example. There are other religions that also have very particular views surrounding pregnancy that do not overlap with the ones that have been codified in many states. And that's hugely problematic. I mean, apart from the infringement on women's equality, it's an infringement on Jewish people's religious liberty. So again, it's not just there's again, it's always a problem when the state favors one religion over others for members of religious minorities.
Yeah, so kind of staying on the same Supreme Court vein, I'm curious if maybe you can give us a commentary on what are some of the lasting impacts of a lot of these opinions that they've given in some of their cases. So whether it's like the 303 creative or again, like the Kennedy v. Burtram, and I only refer back to that one because we've had several people on the show talk about it, and one person in particular, Andrew Seidel from Americans United, he got really animated when I brought up like the limit test and how that particular case seemed to have dissolved that test. So I'm wondering if maybe you can talk about what are the lasting impacts on some of these decisions out of the Supreme Court with regard to religious liberty.
Yeah, I mean, each case is another step in aggrandizing religious exercise at the expense of other values, and at the same time really diminishing, if not throttling, the Establishment Clause. And so I think Bremerton is a good example. Yeah, Bremerton is among the most recent cases that the outcome is not just problematic, but it's precedential force going forward. So again, I don't know how much doctrinal con law your listeners are interested in, but the Lemon test that Andrew mentioned was basically the test for deciding whether something violated the Establishment Clause, and it has two basic requirements. The first of which, the primary purpose of a law can't be religious, right? You have to be able to articulate a valid secular reason for law. Otherwise, it's just theology, right? You're just codifying theology, which is not what's supposed to happen in the United States. So there's got to be a secular reason, right? And part of my argument with abortion bans is there's really not a secular reason to say you cannot have an abortion from the moment of conception. There's not a secular justification for that kind of a law. And the other argument is that a law can't have a primarily religious effect. It can't, for example, force you to participate in a religious exercise not your own. So that's right. So that's a sort of the two kind of questions court would ask when they were faced with an Establishment Clause challenge to something like prayers before a meeting. Or prayers at school. And the court has long held that school-sponsored prayers really raised some serious Establishment Clause challenges. First, because what is the purpose of praying at school? Like, the primarily purpose of prayers is to honor God. That seems pretty religious. That alone should violate the Establishment Clause. But its effect is also problematic, because imagine that it's the start of the school day and the teacher has everyone rise and say a Christian prayer, and you're not Christian. Like, you're Muslim, or you're Jewish, or you're an atheist, right? What are you going to do? You're going to, like, chances are you're going to go along with it.
True.
Because you don't want to be the atheist in the class where everyone else is a devout Christian, or you don't want to piss off your homeroom teacher who's also grading you in all your other classes, right? There's an enormous pressure on students to participate in a religious exercise not their own. What does that mean when you're a Muslim participating in or maybe a Jewish person saying that Christ is our savior? No, that's a violation of your own religious liberty, right? Again, that's what I keep trying to say, is the Establishment Clause is so important for protecting the rights of religious minorities, which includes members of minority religions and people who don't belong to any religion at all, right? If you're an atheist, you may not want to pray either, right? That's contrary to your own deeply felt conscientious beliefs. And so historically, the court has said school-sponsored prayers is an obvious violation of the Establishment Clause. It's not allowed, right? It's too easy for students who are young, impressionable, pretty powerless in school, right? They're under the control of their teachers, certainly subject to peer pressure, right? It's too easy to have Christian prayers force them to violate their own religious beliefs. Never mind, again, that once you say, as I mentioned earlier, there's a favored religion, you have religious insiders and religious outsiders, you have first-class citizens and second-class citizens. So again, like, school prayers, school-sponsored prayers really undermines both the religious liberty and the religious equality of those who don't belong to dominant religions. So I've spent a lot of time talking about why school-sponsored prayers are so problematic in school, because Bremerton was about prayers in school. And it was about a coach who prayed, a Christian coach, because again, it's always Christians who feel privileged enough to insist on their right to public religiosity. And I don't think that's an accident. But who said, my religion requires me to pray after football games in the middle of the football field. And the schools were, and he would do it. And of course, he would invite the other team to join in. His kids would join in. One student said to his mom, I didn't want to, but I was worried if I didn't, I wouldn't get playing time. And this is a coach with a lot of influence over kids and can, make or break whether you get a scholarship or not to some place, right? I mean, this is not there's a huge power disparity here when we're talking about teachers and students. Anyway, and so there was a challenge. And one other thing I should say is that the school was like, we understand that it's important for you to pray, but you have to understand we also have to worry about our students, and we don't want you unduly influencing them. So if you don't mind, would you please pray either on the sidelines, or if it's really important for you to pray in the middle of the football field, like, can you wait until the games are over and the students have gone? Right? So just to be clear, this was never about whether he had the right to pray or not. He did. The school never denied him the right. The question was, did he have the right to pray in front of his students in the middle of the football field immediately after games? And the lower courts were like, yeah, no, it's like that violates the Establishment Clause. We really don't want students to feel compelled to participate in these prayers because you're such an influential I mean, it's a coach, right?
Mhm.
Coaches have huge influence, maybe even more than teachers, which is wrong. I'm
Yeah.
sorry. But they're hugely influential. And so, if you had looked at the precedents, it could have been an easy call for the court to say, we want to make clear that his right to pray should be honored, but there's a limit to that, and there's some questions about whether or not he was coercing other students to participate as well, even inadvertently.
Yeah,
That's not what happened.
yeah. I mean,
What happens?
like outside of the Kennedy v. Bremerton, I mean, could you even have a 303 creative, a Dobbs, or like the I forgot the bill numbers, but like the ones in Texas where they were going to have the 10 commandments and then I think have a prayer over the speaker, and I think those two got shot down, but the one that didn't was like the chaplain one where
Oh yes, they wanted to replace school counselors with Christian chaplains. I don't know enough of the details about this, because if what they wanted to do was, in addition to the secular counselors, they also wanted to offer chaplains for all the religions of students there, that would be one thing. But if they're actually preempting the secular options or only offering one religious option, that would be clearly, or should be, problematic.
yeah.
Although I don't know.
Mm. But do you think that like a 303 or Dobbs would be possible if the Kennedy had gone the other way?
Oh, okay. Sorry, I didn't let you
Mhm.
finish answering your question.
It's okay.
Um, I so 303 Creative was separate and apart from Bremerton.
Mm.
So I think Bremerton was really more about further limiting the Establishment Clause, because one of the things the court said was not only the way they dodge it is they said, oh, the coach was just on a break. It was a private prayer. It doesn't even trigger the Establishment Clause. And by the way, the only thing that violates the Establishment Clause are things that have long historically and traditionally violated the Establishment Clause. So they dodged the whole Establishment Clause question. At the same time, they eliminated the Lemon Test as the touchstone for evaluating Establishment Clause challenges, which means now that it is no longer required for courts, for laws to have a primarily secular purpose and have a primarily secular effect. Those are no longer going to be the focus of the court's analysis anymore. Instead, it's going to be, well, is there a long history and tradition of this practice? And if so, right, if they did it at the founding, then it's no problem. You can do it today.
Mm-hmm.
And of course, yeah, like we really cared about religious minorities at the founding. So, yeah, it changed the test. So I think the new test will make it more likely that Texas can get away with that kind of thing. Because again, they're not going to be asking, well, what's the reason why you want chaplains instead of counselors at schools? And is this going to have a religious effect on students? Like, how is it going to affect people whose faith does not match
Mm-hmm.
that of the chaplains?
Right.
They won't be asking those questions as much anymore.
Yeah.
I don't know if they've eliminated it, but it's not going to be their focus. So
and it's
they're gonna switch to history and tradition, which is endlessly manipulable. You can
yeah.
find anything you want in history and tradition.
Mm.
And so it just makes it very easy to get the results they want while claiming it's principled when it's not.
Yeah, and it's almost like if there isn't going to be a religious element to it, then why do we need chaplains? Like why couldn't we
Right.
just use
Again, So yes, if we had applied the Lemon test, the first question would be, well, what's the purpose of bringing in chaplains to school?
Mm-hmm.
I mean, I'm sure they could come up with one to provide counseling for those who flourish under religious counseling.
Mm-hmm.
Uh, but it would be harder to justify.
Yeah.
But now they don't even have to bother.
Yeah. Is the US kind of like the only country that has, issues with religious liberty?
Oh, I that's a good question, but I'm not the person to answer that because I focus exclusively on US constitutional law. So, no, I mean, I think we all can think of other countries that are actual um sort of theology but yeah, that's not really
Yeah, it's fine. I didn't mean to put you on the spot.
yeah, no, I'm like, yeah, not my area of expertise.
Well, what about the pandemic? Like how did religion meet constitutional law with a lot of exemptions, revolving around vaccines and, shutdowns and all that other kind of stuff?
Yeah, I think this is another example of the way the Supreme Court has been so willing to privilege religion above everything else, including public health. So, part of that public health is women's reproductive lives, but part of that health was also safety during the epidemic. Um, and the thing about religious liberty is, as with any right, it's not absolute, right? Constitution, no constitutional right is supposed to be absolute. There are supposed to be limits on everything, but it seems like this court keeps keeps eliminating those limits, and has been sort of tending towards making it more absolute. And I think that was somewhat true in the COVID cases, particularly the way they disregarded the public health determinations of the Department of Health in these cases. And so, right, the very, I mean, there were different regulations focusing on different things, but some of them were treating large gatherings where people sat and spoke to each other for long periods of time. They would treat that differently than like going to the supermarket. And the thinking behind there is it's more dangerous, right? You're in close contact for a long time. You're chatting with each other. It may not be well ventilated. It's not like going to a store where you're moving around, you go in and out, right? So there are questions of time and exposure. And so there were public health determinations that one was more dangerous than the other. And the Supreme Court was just like, yeah, we don't think so, and just disregarded it. We think they're comparable.
Mm-hmm.
Or they made a determination that sort of gatherings in homes provide more risk than gatherings of 3 or more families at home provided more of a risk than 3 or more gatherings in a public place, because in a public place the ventilation is better, you can see whether people are wearing masks, it's not as social, right? These were like, given the best public health knowledge at the time, the determination is these things were not at all the same, as opposed to people gathering in people's homes. Who knows what kind of ventilation is going on? Who knows how long they're hanging out together? Who knows whether they're wearing masks or not? And they're like, it's not. And the court was like, yeah, we don't buy it. We think these things are actually exactly the same. So it's an example of how far they're willing to sort of distort the facts or ignore facts, not just the law, to really get the outcome they wanted. And so I don't think they've gone as far with people who refuse vaccinations, but I don't know what happens, because some of those decisions have again created a precedent that basically says, if you have one secular exemption, one secular thing that we say is a counterpart that you're treating more favorably than the religion one, then we consider that discrimination against religion, and you have to provide the exemption unless you can provide a really compelling government reason for it, and you can't,
Hmm.
basically. And so basically, anytime the government has a law, and if it makes one exception, even if like there are 100 examples and sort of 99 of the religious ones are treated better,
Mhm.
but one secular one is treated worse, the court will say that's discriminating against religion, and therefore you have to allow the exemption that's sought.
Hmm.
So, for example, with vaccine exemptions, say you like everyone must get vaccinated. The only exemption is for people who are actually going to have an adverse reaction. They'd be like, you have a secular exemption. If you're willing to give an exemption for them, then you should be willing to give an exemption for religious reasons. It hasn't done that yet, but the law is there to allow them to do it.
So okay, so as you're talking, it got me thinking, like, how does the government view a religion? I mean, like, if I said part of my religion is I don't know, I get to kick dogs, like it's part of a ceremonial ritual.
Mm-hmm.
Um, like, would I be able to do that?
So basically, if there was an animal abuse law that says you're not allowed to kick dogs, or you can't hit or beat animals, um, so there's separate questions. One is, would it your religious belief has to be sincere, so that's one threshold. Courts tend not to analyze sincerity, but they might, especially, right? Again, there's a little bit of discretion.
It's
Second,
subjective though, right?
huh?
Because sincerity is very subjective, right?
There's a real worry that analyzing the sincerity of someone's belief is going to slip into analyzing the validity of their religious belief, and that you can't do. You can't say, what your religious truth is or is not correct. Like that, the court can't do. And sometimes sincerity and validity is a little hard to parse. So courts tend to be deferential with regard to sincerity, although not always. Particularly if you say your religion requires you to smoke marijuana, right? That
Mhm.
or use drugs. Like those are cases where they're like, yeah, you formed that church right after we arrested you for drug possession, right? So they're not wholly deferential, but they do tend to be deferential when it comes to people's beliefs.
Mhm.
Okay, and then the law is, well, again, there's what the official law versus what actually happens now. The official law is basically, if the law is neutral and generally applicable, if it's not targeting religion in any way, then you just have to obey the law, right? So if the law is no abusing animals, it doesn't matter if your religion requires it, you just can't do it. There is, however, that's only true if the law is neutral and generally applicable. That's the lingo, neutral and generally. What the COVID cases said, it's not neutral and generally applicable with regard to religion if you make an exception.
Mhm.
If there's a secular exception, that was what I started to say before. If there's a secular exception to that law, then you also have to make an exception for religious reasons. So, if there is an exception, like you're allowed to harm animals if they pose a danger to the public health,
Mhm.
say, then the religious people might argue, well, that's a secular exception. If you're willing to make an exception for secular reasons, then you have to make an exception for religious reasons too. And therefore, I am entitled to the exemption unless the government can show that there's a really compelling reason not to give me this exemption.
Huh.
So, as crazy as your example is, and as much as a no brainer as you thought it would be, and I still think that you would lose, it's no longer guaranteed under the existing law.
Hmm. Yeah, I should just say for the record, I'm not in the business of kicking dogs.
I did not think you were in the business of kicking dogs.
It was it was like there was a bunch of stuff whirling around in my head for examples I could use, and I was like, okay, this one probably won't get me arrested or a call by the FBI, so I'll just go with this one. So, um, okay, so
The law basically now is, right, you are entitled to an exemption unless the government can provide a really good reason why you shouldn't get the exemption. And whether the government has a really good reason will very much depend on some of the court's values.
interesting. Okay, so in the last remaining time we have, I want to tap into some of your First Amendment expertise here, if I could, because I've got two questions. One regarding free speech, especially in light of the Trump stuff. Free speech, whatever. And then the next one deals with misgendering.
Can we talk about, I'd rather talk about misgendering.
Okay, all right, that's fine.
And even 303 creative, which we didn't get to. I think it's actually, can I just make that point before we get to misgendering? I think that the most recent decision we saw was religious liberty claims are not just brought under the religious liberty clauses or statutes. We also see free speech being used to advance sort of the right to discriminate. And that's what happened with the 303 creative case, because ultimately we had a Christian store owner who wanted to get into the wedding business, but did not want to provide services to same-sex couples. And so she claimed that it violated her free speech if she's forced to obey anti-discrimination laws.
Which is weird. Like, I don't understand that, because like she didn't even have like a customer, right?
Yeah, that is a little weird, but you can have pre-enforced, like you can challenge laws before you actually violate them. Although whether it was truly ripe or not is a fair question. But more disturbing than the fact that they were super keen to hear the case and were not worried about some of the procedural things they might have raised in other cases, whereas their willingness to say that providing a service can to a same-sex couple can violate your free speech rights. And so it is yet again a way we see the religious person and their needs prioritized over communities that have long suffered from discrimination. And so they're very sympathetic to the Christians who don't get to live their life exactly as they want. And they have very little sympathy for those groups who have long been subordinated in our country, long been the target of discrimination. And so I fear that we're only going to see more of that. And I think the misgendering is another example. So did you have a particular question about that?
Yeah, it was kind of focused on what you wrote about when teachers misgender. And I'm only asking because I have a friend who's a teacher, and they have stated, and I'm paraphrasing here, that they didn't feel comfortable, perhaps using the individual's, preferred pronouns or whatever the case may be. And I'm curious on, like what types of free speech issues does that present for, I don't know, for the school, for the teacher, for the student, what have you?
Well, I did write a paper about this, and one of the interesting things that I uncovered is that there are many professional code of ethics for teachers. And the first one was always, you should make sure that the children that are under your supervision feel welcome and comfortable and able to learn.
Mm-hmm.
And they can't if they're being intentionally misgendered. So separate and apart from all the legal questions, which I'm more than happy to talk about at great length, I really want to emphasize the professional responsibility of those in the teaching profession to honor their commitment to teach all the children who are in their class and to provide them all with equal opportunity and equal access to the knowledge that they have. And I think that's really important. Legally, teachers don't have a free speech claim in K through 12 because their speech in discharging their duties is actually not their speech, but the government's speech. So in free speech law, there's a distinction between private speak, which the free speech clause protects, and government speech, which the free speech clause does not. If you are a public employee, if you work for the government, if they're paying you and what you're doing is what they pay you for, if your speech is pursuant to your official duties, that's the legal phrase. If you are discharging your obligations that you have been paid to discharge, then that's the government's own speech and you can't challenge, and you have to do what they tell you. So they don't have a free speech right to misgender. So if they're uncomfortable, then they either have to work on overcoming that, or they might have to find a different way to make use of their training.
That's interesting. I mean, there's going to be a lot of like voucher schools, I'm sure, out there, right?
Yeah, so it'll be an interesting question how this plays out in public-private partnerships and how those are treated. But which is why I really started with the ethical obligations. It's sort of it's like, I'm sorry you feel a little uncomfortable, but your comfort is not the primary focus.
Got it. So I guess my last question, what are some of the things on your radar that you're looking at, waiting to see how it unfolds kind of in the First Amendment world?
What are things? I don't know. I'm not sure. Let me say these are last words, right? Okay, let me I think I'm gonna answer a different question.
Okay. Yeah.
Because I think I didn't expect to do this, but this sort of turned into a plug for the Establishment Clause. When we think about religious liberty, it's so important to remember that religious liberty is for everybody, not just conservative white Christians who want to discriminate or deny health care. And I really think that this commitment, if you really are committed to religious liberty, you should be equally committed to the Establishment Clause. And that we really it needs to be stronger to protect everybody's religious liberty. And I guess the second point I want to make is religion is so important. I totally favor religious liberty in terms I don't think the government should target religion for disfavor. I even think that religion should sometimes be privileged over its secular counterparts as long as it doesn't hurt anyone. Right? So I don't think the government can say, to ban hijabs or yarmulkes because they don't like religion. And I even think it's okay if the government says, people can't wear hats like a secular counterpart when they get their photos taken, but they can wear hijabs or yarmulkes. So I hope I don't come across as against religious liberty. I'm not, even for the majority religions. But where I draw the line is when your burdens of your religion harms other people. And that's where I really think it's important to understand that religious rights are important, but they're not absolute. And I think they should yield to equally important values like not inadvertently killing people with a pandemic, or respecting the equal dignity of everybody, right? And that means, part of our social contract is that we agree to treat everyone in the public sphere provide them with equal access and with equal dignity, and allowing certain organizations to discriminate is so contrary to that. And I think that's the point at which religious liberty has gone too far, especially when it's the religion of the already powerful at the expense of the long discriminated against.
That's awesome. Well, thank you so much, Professor Corbin. Oh, I forgot to ask you, is there anything you want to plug, website traffic, anything like that?
I've written about a lot of these things. I suppose I can send you the page that has all my publications.
Okay.
So,
Yeah, that'd be great. Yeah, I'll make sure it all gets put in the show notes. I
but
just want to.
mostly I want to plug the Establishment Clause.
Cool. Cool. We are very pro establishment clause here on the show. And yeah, we really appreciate all your insight and expertise. And yeah, good luck with the rest of your research.
Thank you, and thank you for having me.
Yeah, you're welcome. Bye bye. All right. So we stop recording. Yeah.